To this story now, could South Africa's former Chief Justice become the country's Commander-in-Chief? Mogoeng Mogoeng has accepted a nomination to become president of the newly formed All-African Alliance. It intends contesting the next national election in 2024. But what are the laws and regulations regarding what a retired judicial officer can and cannot participate in? Well, we're joined by legal expert Advocate Greta Engelbrecht to speak more on this. Ms. Engelbrecht, thank you very much for your time this morning. Now, beyond the political debate around how the former Chief Justice would fare, there's that legal debate or conversation now around what a retired judge can and cannot do as per the Judicial Service Commission Act. Just talk to us about this.
Yes, so thank you for having me and good morning. The starting point for all of us, of course, is always the Constitution. And it's the importance of the judiciary being seen as subject to the Constitution only and being independent. And of course, judges have an oath of office and they have to comply with the laws. And that, I'm afraid, may stand in the way of former Chief Justice Mogoeng Mogoeng. There are two main acts that apply, and the one is the Judges' Remuneration and Conditions of Employment Act, and the second one is the Judicial Services Commission Act. And the real issue is that judges, when they retire, what we see in the public eye as them retiring is just their release from active service. So they continue to be paid, they continue to receive remuneration, and they may be called back to actually serve for limited periods of time when it is required. So they remain judges and therefore remain subject to the regulations. And one of the issues here is there is a code of conduct that applies to judges, and it has certain notes to it. And one of the notes is a note that says, well, in Article 17(1)(a), they may not accept any appointment that is likely to affect or to be seen to affect the independence of the judiciary, or which could undermine the separation of powers or the status of the judiciary, and must not receive any income incompatible with judicial office. That's the one aspect. And the other aspect is in note 17(4) that a retired judge may not enter party politics. So it's expressly stated that a retired judge may not enter party politics.
I read that code of conduct, and the words may and must, I know, are a big deal in the law, because if it says may, our understanding, humbly so, is that there is an election, it could go either way, but must is then definitive in this respect. I see that with Article 17(4), it actually states that they must not enter party politics. But when we look at the Act itself, the Act is far broader. So what comes before the other? Because it states that they may actually, with the consent of a minister, perhaps be allowed to take up any other role. So what comes first? Is it the Act, and then we have the Code of Conduct that gives expression to the Act, or is it the other way around?
Yes, so the Act is always primary. The Code of Conduct is what we call secondary legislation, and so it must be interpreted subject to that which is stated in the Act. But that is, of course, where the issue lies, because the minister is the one that will consider whether or not a retired judge can take up another position or another appointment, and he will have to make that decision in conjunction with the current Chief Justice, or he will have to consult the current Chief Justice on something like that. Now, when a minister will have to consider a request such as that, he will take into account the Code of Conduct. And the Code of Conduct that was adopted and published says in express terms that there is a prohibition, as it were, on a retired judge taking up party politics. So it would be highly unlikely for a minister, in the face of a properly adopted Code of Conduct, to then give a former Chief Justice, for example, permission to enter party politics.
So you're not saying that, as we've seen with regulations at times where we'd find in the court where they say the regulations are not giving clear expression to the Act, they're misaligned, we want you to go rework them. We know with the finance minister around the BEE matter, there was also some sort of a misalignment there, and they've actually forced them that you either need to realign your regulations to the Act itself. So you're saying in this instance, you don't see the Code of Conduct being seen at some point to have been misaligned to the Act, which is broader and states that at least in this instance, the judge who has been discharged from active service may only, with written consent by a minister, hold or perform any other role. You're saying you don't foresee some sort of challenge to the code itself, the Code of Conduct?
Well, there might be a challenge. The question would be whether such a challenge would be successful. And that challenge, one would have to see if anybody brought such a challenge. But it would have to not only look at the Act itself, but look at the broader purpose of protecting the integrity of the judiciary. The Act gives expression to the Constitution. And the Constitution places a very, very high value on the independence of the judiciary and the retention of respect for the judiciary. And once the lines become blurred between the judiciary, former judicial officers, for example, and party politics, there is a threat, I would suggest, to the separation of powers that stands so centrally in our Constitution. So the regulations would have to be considered not only by reference to the Act, but to the Constitution. And I'm not sure that a challenge to the Code of Conduct would be successful.
Speaking of the Constitution, then comes to the recent judgment around the Electoral Act itself, which found it was unconstitutional on the grounds that it doesn't allow citizens to be elected to the national and provincial legislature. Is this now an exclusion of judges or not? Because this is also a debate among many now, legal eagles as well as ordinary citizens who want to hear from legal experts. Does this exclude them?
Yeah. Well, the problem is one returns again to the specific legislation that regulates judges. If one, for example, and it may be a little bit off the topic, but if one considers that we've got a provision in the Constitution that allows for freedom of trade, occupation, and profession, but just like every other right in the Constitution, that right may be limited by a law of general application. It may be limited if it's reasonable and justifiable. Now, that limitation on the position of a judge, in other words, setting the judge potentially aside from the remainder of the citizenry, that may be considered a justifiable and reasonable limitation on that person because of the importance of the separation of powers, and also because the judge remains as it were, paid employee, not an employee in the sense of active service anymore, but still being paid. So there must be and may be limitations.
So what could this mean? What was the thought behind it? And as much as we cannot speak for the CJ currently, but many now are questioning whether he would have been aware of this when accepting this nomination or not. Is it something that is easily accessible? Because I went through the Act quickly last night and the Code of Conduct. Is there some sort of confusion that would really exist?
There can't have been confusion. It is important that under the relevant statutes, the Chief Justice is the person who is initially responsible for the adoption of the Code of Conduct and then for its maintenance. So former Chief Justice Mogoeng Mogoeng was the person who was responsible for the maintenance of this Code of Conduct. So he can't say that he was not aware of its provisions. And in any event, it would be highly unlikely for somebody who held that sort of high office to say that he wasn't aware or didn't make an attempt to inform himself.
But I must state that we haven't as yet spoken to the Chief Justice to find out on his part if in fact he has accepted nomination. So it's purely academic at this point, where we're trying to understand that any other retired judge, would they be allowed to participate in politics or not? Ms. Engelbrecht, thank you very much for your insights. I think we're a bit clearer on this matter. That was legal expert advocate Greta Engelbrecht.